Good morning, good afternoon, good evening. Welcome, everyone. People are still connecting up, so we'll wait for a couple of minutes before, more like 30 seconds before we get started. Okay, thank you for joining us for this very first event following the publication by Wolters Kluwer of the book International Arbitration and the COVID-19 Revolution. It is a brainchild of Professor Maxi Scherer, Professor Mohamed Abdal and Niuscha Bassiri, who pulled the book together in record time, and we're privileged to have all three of them with us today. As far as I can tell, this is also the very first book dealing with the impact of the pandemic on the practice of international arbitration, let alone one doing so systematically and analytically. We are also privileged to have with us today Gary Bourne and Anneliese Day QC. Together, we ran a global survey on remote hearings earlier this year, and our initial findings were included as chapter 7 of the book. Over the next 30-40 minutes, we will explore together the contents of the book and the findings from our survey, both those that are published and further findings that we'll be publishing soon. This will be followed by a Q&A, and please feel welcome to use the Q&A function, which you'll find at the bottom of your screen, to send us questions. Now, this introduction will not be complete without saying a few words about our distinguished speakers. None of them require an introduction, but if I may, in a few words, all of them are leading practitioners who act as counsel and arbitrators internationally. Professor Mohamed Abdal joins us from Cairo. He heads up the International Arbitration Practice at preeminent Egyptian law firm Zulficar and Partners, which he co-founded, and he teaches at the University of Cairo. Niuscha Bassiri joins us from Brussels. She is a partner at the acclaimed boutique firm of Hanotiau in Berg and teaches at the Brussels Management School. Professor Gary Bourne is currently in London and outside of the pandemic, divides his time with Singapore. He chairs the International Arbitration Group of leading law firm WilmerHale and is the author of the leading treatise on international commercial arbitration, the third edition of which will be out shortly. Among his many hats, he also chairs with Anneliese the design committee for Delos' London Hearing Center, known as LONDAP. Anneliese Day QC is also in London and a member of Fountain Court Chambers. We know her as a standout practitioner in arbitration, but she also ranks as band 1 in many different other practice areas. Professor Maxi Scherer has connected up from Berlin, and we are told that she's got an amazing view of the Reichstag. She's a special counsel at WilmerHale, teaches at Queen Mary University of London, acts as a general editor of the Kluwer Journal of International Arbitration, as well as sitting on the board of advisors of Delos. None of these biographies are extensive, but they'll give you a flavor of the caliber of our speakers today. For my part, I'm joining you from Paris. I'm the president of Delos Dispute Resolution and also sit as an independent arbitrator. Without further ado, I will hand over the floor to Maxi to introduce the book of the day.
Thank you very much, Hafiz, for this kind introduction, and for Delos for hosting this event, the book launch of this book, International Arbitration and the COVID-19 Revolution. We all know that the pandemic is a terrible thing that has affected and is still affecting the world as a whole, has had a terrible toll on people's lives and health and economies around the world. So there is no surprise that international arbitration as well has been affected quite deeply. As you said, we have put together this book, which we believe is the first that looks at the effects of the pandemic on international arbitration holistically. We could not have done that, and I think our thanks here are also due to the publisher, Wolters Kluwer, who has had an amazing support, who has turned this around in no time, for this publication to be so timely. And of course, the amazing group of renowned authors, 3 of us are with us here today, but also many others. Without their commitment and dedication, we would not have been it would not have been possible to publish this book. Anyone who has been in a multi-author project knows that this is challenging even in the best of times. This was done during the pandemic and with a very ambitious timetable. The book looks at the effects, as I said, of the pandemic on international arbitration holistically, both from its procedural aspects and substantive aspects. And Mohamed and Niuscha will detail those aspects in a moment. I would just like to outline the twofold ambition that we had with the book. The first is to provide practical guidance for the users of international arbitrations, be it parties, be it counsel, arbitrators, or institutions when they face these new challenges during the pandemic. But also, and this is the second prong of the ambition of the book, to consider how this COVID-19 revolution, as we called it, will affect the international arbitral process as a whole and for the years to come, even after the pandemic. And here we believe that there is maybe a bit of a silver line on the horizon, that there is the potential for a positive with this whole terrible pandemic. And that is that COVID-19 might be seen as a catalyst for some changes in international arbitration, which is the most popular and most common means to resolve international commercial disputes, to make it even more effective and even more efficient. Just to give you one example, we're going to talk quite a bit about remote hearings. The idea here is not to plug into any sort of video conference technology what we have done in the past decades, but to think again and consider how we can adapt the process to make it, to tailor it to the specific needs of a specific case. So that's the double ambition of the book, provide practical guidelines, but also consider the more long-lasting effect the pandemic will inevitably have on the arbitral process. With that, I will hand over to Niuscha to talk a little bit more about the procedural chapters of the book.
Thank you very much, Maxi, and thank you very much also to Delos and in particular to Hafez, Gary, and Anneliese for joining us today. I will indeed go through the procedural chapters of the book to introduce them to you, but also the authors, and to give you a glimpse what they have analyzed in such a meticulous and speedy manner. The first one unpacked, we have heard the word catalyst, is indeed a chapter about dispute prevention, management, and resolution in times of crisis between tradition and innovation. And here comes the COVID-19 Catalytic Crisis by Mohamed Abdal Wahab, one of the co-editors that I had the pleasure to work with on this. And it looks at the theoretical framework of crisis management, and also at very aptly at the interdisciplinary approach, how to adopt crisis management to dispute prevention, management, and resolution. It gives a very good advice, I would say, in particular to enterprises, to in-house lawyers, but also to external counsel. The second chapter by Patricia Shaughnessy is on initiating and administering arbitration remotely. And she has gone through the response that arbitral institutions have given right at the beginning in a very efficient manner to the disruptive consequences that this pandemic had and still has on arbitration proceedings. And she analyzes the procedures of remote administration of cases and how this has been, in fact, enhanced through technology, of course. Then the third chapter, co-authored by Catherine Rogers and Fahira Rodlia, looks at the arbitrator appointments in the age of COVID-19. They analyze that there has been, and there still is, a bottleneck of information deficit on arbitrators, and they also look at specific skill sets that maybe now through COVID-19 has become relevant, even more so than before. We're talking about technology in particular, and also that this pandemic has maybe opened up even further the possibility of diversity of arbitrator appointments. And the fourth chapter is by no one else than Maxi Scherer on the legal framework of remote hearings. And here she looks at the legal basis of remote hearings, what do the laws say, what do the rules say, and in particular, also with a focus on a very difficult question, how to balance the situation if one party is opposing having the hearing held remotely, whereas the other one is actually an agreement. So from a tribunal's perspective and also from a counsel's perspective, quite an important analysis. The fifth chapter is on conducting remote hearings, issues of planning, preparation, and a sample procedural order that I have attempted to put together by actually taking the position once then the decision was taken to actually have the hearing conducted remotely. What are the practical considerations and also procedural considerations that a tribunal needs to take into account? The sample procedural order is also added by commentary on all provisions that are suggested, and I hope that this will be a guidance for arbitrators and counsel alike. Wendy Miles in chapter 6 looks at remote advocacy, witness preparation, and cross-examination, and gives practical tips and challenges, or looks at challenges as well. Now, she looks in particular at the effective advocacy in remote hearings, and also the change of approach that needs to be taken, and that will be actually on a more focused level. For example, considering whether at all every witness that you have on your list should be cross-examined, and gives a very insightful suggestion on how to save time and cost, but also still deal with the complexities of the arbitration. Chapter 7 is by our esteemed authors who are here with us today, an empirical study of experiences with remote hearings, a survey of users' views. Gary Bowen, Anneliese Day, and Wahab have done an amazing job, also in a very speedy manner, to get a survey out, to get the questionnaires out, circulate them, get answers in, and analyze them. We will hear about the analysis in a short while. Chapter 8, authored by Eric Schäfer, looks at e-signature of arbitral awards and the situation that once we actually might go all electronic with evidence, what about the legitimacy of digital awards as well? He looks at the technical hurdles that still exist, but also at the legal framework that is available, and makes a call out to arbitral institutions to join together and making it happen to take the next step for digital awards. Chapter 9, written by Erika Stein, looks at challenges to remote arbitration awards and setting aside and enforcement proceedings. Now, she actually suggests that most of the decisions that a tribunal would be taking are decisions in the ordinary course, so ordinary procedure, and doubts whether there are actually situations where an award could be challenged on the basis of a tribunal taking the decision to hold a hearing remotely. On this, as a little side, there has been an OGH, Oberster Gerichtshof, decision by the Austrian Supreme Court, and it actually doesn't follow exactly 101 what Erika Stein has already written, but indeed, because it is about the challenge of arbitrators, not the challenge of the award. But Maxi Scherer, with two of our colleagues, have actually analyzed it in a blog very well, and it's also worth a read. Then we have chapter 10, third-party funding and the COVID-19. Exposure by Dana McGarth, Chen Ying Kong, and Annie L'Esperance and Niloufar Hussain from Omni Bridgeway, third-party funders themselves. And they analyze the fact that, in fact, the COVID-19 pandemic has enhanced the call for more funding. So there is an increasingly sought after third-party funding by either counsel for their clients or the clients themselves, the enterprises themselves. Chapter 11 looks at the future, the COVID-19 revolution, and the future of international arbitration is not over yet. As Emma Vidak-Gojikovic and Michael McElworth have analyzed, they look at various techniques, what has been done, what can be done, and how arbitration will be still ongoing. We're not seeing the end, but how it will never be the same anymore in their view, because of the adaptations that were necessary to take now to the arbitral process. Just one last word about the appendix. Conducting remote hearings against a party's wishes. An overview of arbitration laws of main arbitral seats has been put together by Amina Afifi. And with that, I give now the floor over to Mohamed Abdul Wahab.
Thank you very much, Niuscha. It's a tour de force, and delighted to be here with everyone. And again, a great pleasure to contribute to that book. So thanks very much to Maxi, Niuscha, Hafiz, Gary, and Anneliese for being with us today. Briefly my task is to walk you through a little bit of the remaining 6 chapters, which are more of the chapters addressing substantively different sectors. And these sectors and the chapters actually from 12 to 17 address very important sectors: construction, energy, aviation, technology, media, telecommunications, finance, and insurance. To start briefly with, and I won't be able to do each chapter the justice deserved for the authors, because they're all excellent chapters that I encourage you all to read, of course. The first one is chapter 12, which is COVID-19 and construction disputes by Todd Wetmore and Simon Elliott of 3 Crowns, where they explore the effects of COVID-19 on construction disputes spanning the globe and the measures taken, including a comparative analysis from both civil and common law perspectives. The different aspects of construction disputes, both the industry and the disputes themselves. Then in chapter 13, dealing with the energy types of disputes and transactions, Sama Haridi and Samuel Zimmerman of Hogan Lovells explore the effect on the energy sector and disputes in a way, and they track the development across the entire globe supply chain, analyzing the worldly responses to the pandemic. Again, a very excellent chapter that deals with energy from a global perspective. The third one is the chapter dealing with aviation disputes by Johnny Champion, Rupali Sharma, and Patrick Bettle of Stevenson Harwood. They also specialize in aviation, and we know that this is one of the sectors that has been hit heavily with the COVID-19. And they address this again from the perspective of the industry and the disputes and the significant liabilities and crises that the sector has suffered. They explored issues about aircraft leases, purchase agreements, doctrines of course of hardship, force majeure, frustration, and the like. Then we have our 4th chapter, which is chapter 15, COVID-19 Technology, Media and Telecommunications by Olga Hamama of V29 Legal and Daniel Herman of Newland Legal, where they explore the impact of COVID-19 on the technology, media and telecommunication sectors from the perspective of both, again, the industry and the disputes in relation to aspects of broadcasting, remote working, variations, software and hardware applications, of course. They also explore the changing nature of the TMT industry and the way competition and digital innovation is transforming the industry and revolutionizing it in light of the pandemic as well. Then we have chapter 16 dealing with finance disputes, and it is entitled The Eye of a Perfect Storm. It's by Philippa Charles of Stewards. She explores the effect on the disputes and the financial sector, and addresses the complexity of this sector and the arising disputes in light of the COVID-19 pandemics and its impact on businesses and governments globally as well. It also sheds light on aspects of fintech, blockchain and cryptocurrency projects, either in the pipeline or for future reference, of course. And then the final chapter, which is chapter 17, deals with COVID-19 and the insurance sector and disputes by Alexander Oddy and Chris Parker of Herbert Smith Freehills. They explore this from the perspective of insurance and reinsurance markets. It is primarily, this chapter is written from the perspective of an English common law system, understandably because of the influence of English law on the insurance and reinsurance markets. They also address the very timely and very recent English High Court case, the Financial Conduct Authority versus Arch Insurance, which was released and handed down in September 2020, largely in favor of the policyholders. So by and large, these chapters, again, they both address the industry practice, which I think is very innovative, and the disputes in relation to the global pandemic. One final word from my side to fully align myself with what Maxi and Hafiz have mentioned, as well as Niuscha, is that this book, even though it's entitled International Arbitration and COVID-19, is really a contribution towards similar crisis. So even though it's COVID-19 specific as an illustration, it does shed light on aspects that will undoubtedly be very useful even for future, not just pandemics, but similar crises that would span the globe. Thank you very much. Handing it over.
So I think we've given you an overview of the various chapters of the book, which is already available online and will be available in hard copy shortly. We are, of course, very happy to address any particular questions at the end, but we will now delve in one chapter in particular, and not just any chapter. It really is one of the core chapters. As Niuscha has already said, initially this is chapter 7, and the 3 authors and an anonymous cat are currently with us in this Zoom meeting. We will ask them questions about the empirical data they have collected with, which we believe is actually the first survey on remote hearings, which has been published in the book, and with some additional data that is still currently being analyzed, and you'll get a little glimpse and heads up on what is yet to come in a future publication. So maybe to start, and Hafez, this is maybe the first question to you, to set the scene. Can you tell us a little bit more about how you did the survey and its methodology?
Sure, thank you very much, Maxi. So we, as you know, the survey is entitled Experiences with Remote Hearings, a survey of users' views. And what we were really trying to get to was, what was the community's experience? How did it relate to this technology? What was the phenomenon? What was its size, and so on? So we conducted it June to July this year with the support of some 50 organizations worldwide, and we thank them for their support. And over 200 respondents completed the survey, coming from some 43 jurisdictions. So it's quite a significant amount of data we were able to collect. 87% of these respondents we have defined as participants for the purposes of our chapter and analysis. And by participants, what we mean is practitioners participating at hearings, related parties, so that's arbitrators, tribunal secretaries, counsel teams, in-house counsel, and experts. The remaining 13% we categorize as providers, namely the providers of arbitration services, which includes hearing centers, arbitral institutions, and technology providers. And those terms will be used in our discussion, so I'm highlighting them from now. The other terms we will use are in-person or physical hearings, which we distinguish from different varieties of remote hearings. Now, for that, we relied on an article that was published by Maxi actually in May, which provided a very useful framework, and I think a lot of us have been referring to it since. And one of the things she addressed, if you allow me, Maxi, is there was a lot of talk at the time of, should we call these virtual hearings, online hearings, remote hearings? Remote hearings seemed analytically the soundest way to refer to these hearings. And to read the definition, it's hearings conducted using technology to simultaneously connect participants from two or more locations. Within the category of remote hearings, we've got semi-remote hearings. So you've got a main place of hearing, and then you connect, for example, a witness via video conference. That's something we've already had quite a bit of experience of prior to the pandemic. And then fully remote hearings, where there is no central hearing venue. And that is really the novelty of this year, but we'll come to that. The final point I would like to mention to answer Maxi's question is time. We divided our survey into 4 significant time periods, which were prior to 15 March 2020, 15 March to 30 June, the second semester of this year, and then 2021 onwards. And the relevance of 15 March and 30 June are the following. As some of you will remember, on 15 March, on 11 March, the World Health Organization declared COVID-19 to be a pandemic. And it's shortly after that that travel restrictions and lockdowns were first put in place. Up until that point, there was still a feeling that we could keep on with in-person or physical hearings, possibly at postponed dates. And what we saw was a transition in the period 15 March, 30 June, where people started doing hearings fully remotely or remotely, publishing guidance, checklists, sharing their experience. And so that time period seems significant to us to isolate for the purposes of the survey.
Thank you very much, Hafez. That is very valuable information on how to understand your survey, how to read it, and how to also, for oneself, analyze where one is in the fantastic charts that you have put together. There are various manners of charts and types of charts. But before we get to that, Gary, how did this first period that Hafez just mentioned, so the period of March till June, look in your calendar? So how actually did your hearings look like? Were they postponed? Were they annulled? Were they kept? Were they shortened, extended? All kinds of variants there.
Thanks, Niuscha, and thanks, Delos and Hafez as well, and Maxi for the enormous work, the monumental work that went into both this book. It must be one of the fastest books ever published on anything, but in particular international arbitration. But that doesn't stop it from being one of the most high quality works as well. I should say about, if I can put it this way, our chapter, Hafez, Anneliese, and my chapter, it's a work in progress. We had to prepare it under a tight time frame. Not many surveys have been done during the time of the pandemic. About a relatively new subject. As Maxi referred to, there was a revolution of sorts. And coming to your question, Niuscha, my own calendar reflected a little bit of revolution, but also a little bit of evolution as distinguished from revolution. I think we all, certainly me, had experienced some measure of remote hearings by our definition prior to the pandemic. I think we've all encountered both fact witnesses, but also other types of participants who have not been able to travel to the in-person or physical hearing venue, and thus had to give testimony by video conference. We've all had case management conferences that have been conducted sometimes by telephone, sometimes by video conference. I think the dramatic change, of course, because of the pandemic, was that stopped being the exception or perhaps minority approach, and instead all of a sudden became either the majority approach, or in many jurisdictions, if you're not in parts of Asia, the only game in town. My own personal calendar moved from a fairly busy schedule of, needless to say, in-person hearings to one that was predominantly remote hearings, and usually fully remote hearings. Some, depending on the case, some hearings were rescheduled. I didn't have any that were put off forever. And my sense from the responses in our chapter to our first few questions is relatively few hearings were basically put on hold without any indication of when they might be rescheduled. Some hearings were conducted. I was in a hearing in Sao Paulo in Brazil, literally the day that lockdowns began to be imposed, and the in-person hearing was stopped and immediately transformed into a series of rolling remote hearings, each one for a particular witness. And I think in a sense that's representative of how arbitration in general responded. There were numerous, and our findings in Chapter 7 bear this out, there were numerous remote hearings scheduled of various sorts, with a variety of changes, both to the length, but also to the way the hearings were conducted themselves, so scheduling.
Thank you very much, Gary. Mohamed?
So yes, I'll just say. Anneliese, again, that question I think is addressed to you. Now you tell me, which did you prefer, or rather, which is here to stay, fully remote or physical hearings? The sort of million-dollar question that everyone has been asking and different views received. What is your take on this?
Well, I think it depends on what the subject matter is. I think it's a nuanced answer. I do think what's interesting is I was looking at the end of our book, which says that people have more in-person than remote hearings scheduled for 2021. But as we go into more lockdowns, I suspect that is going to change. I think what's interesting about the comments that we got back was that it was very nuanced. So again, when you have a survey, I think it's very interesting that people perhaps are more honest. I think that if you talk to most practitioners, they'd be very positive about it because, you know, they want to keep things going, being blunt. But perhaps when, a bit like voting for a US president, when you actually see what they record, it might be slightly different. So I think that's interesting. I also think it's interesting that tribunal secretaries, for example, were overwhelmingly positive about fully remote hearings, and perhaps, you know, practitioners less so. But I think looking at the findings, practitioners definitely are more likely now to recommend fully remote hearings than they were before the pandemic. I think that the other thing that's very striking about the research is the amount in dispute has a big impact on how people view remote hearings. So if for small disputes under 2 million, I think that fully remote is here to stay because it's a very effective way of managing it. You can use perhaps younger practitioners to deal with it. They can be dealt with more quickly, more cost effectively. We found that between 2 to 5 million, it was pretty equivocal. It didn't have a huge effect whether it was fully remote or in person. And then once you get above, Hafez has kindly shared some of the answers we got. Once you get above 5 million, you find that people are less likely to be enthusiastic about fully remote hearings. So I think that's a very interesting finding and probably correlates with our own experiences. I think the other thing that we found was that the answers depended on what sort of hearing you were looking at. So again, if you can go to question 43, Hafez. This was a very interesting finding. There was a sort of tipping point at about 4 witnesses or 4 experts to be cross-examined. That's when you started seeing a shift from people being quite happy to be fully remote to perhaps as likely to want in-person hearings. And then once you got to 6, then there was a definite shift in the balance back to in-person hearings. So I think it very much depends on what you're talking about. And I think that's very important because I think this is not just a temporary fix. It is something that we should all embrace as being appropriate in certain types of cases. And I will be very interested in the next set of data. Hafez, if you go to question 34, again, this was very interesting. One of the benefits of it, of course, cost savings, preserving hearing dates are up there. Functionality, environmental benefits, being able to see the person on the stand up close. But then you drop down, going down to advocacy, effectiveness, being able to monitor the tribunal up close. So it's quite interesting how those change and evolve as we go forward in terms of preferences for one form over another. I'll come back later on to talk about case management. I think that's a fundamental shift that will stay. And it's a very interesting shift that gives the ability to manage. But I think the best thing about it is it's an additional tool that we now have that can be used in an appropriate case.
Thanks a lot, Anneliese, and I indeed couldn't agree more on your last sentence and on the rest you've said, but the fact that this is now part of the toolbox. We are now looking at this as one of the means to conducting arbitration most efficiently. So it might be worth the while in some cases and not in others, and it is very case and fact specific. This being said, and again, turning back to you, Hafez, you asked the respondents about their experience with fully remote hearings compared with in-person or physical hearings. Can you give us a little bit more detail? And I should say, you've probably seen this from the charts that Hafez has just shared to our listeners. There is a wealth of data that the 3 authors have analyzed that we certainly cannot summarize in the short time frame that we have. And I do encourage you to look at the book chapter, which is available online on Kluwer arbitration. And I'm sure they will also be happy to answer any questions at the end. So Hafez.
Thank you, Maxi. And what I'll do is I'll share a figure from our chapter. Let me find the right one. Because sometimes these sort of charts speak much more than long prose. So what we asked people to compare was, as Maxi said, the experience of fully remote hearings versus, in this case, in-person hearings. And the terms of comparison were very simple. It was, do you consider them to be better, the same, or less good? What was very interesting is that a majority of respondents, and you can see this from the chart, actually saw the two as being the same. Where we have a difference is when you start aggregating values and looking at what the overall experience is from a numbers perspective. And there, the aggregated average is actually that people prefer in-person hearings. Now, that's an overall picture. Then you want to drill down a bit. And you've got 9 criteria here, which are 9 defining features of a hearing. And within that, you can segment that into 3 groups of criteria. 6 relate to the examination of experts and witnesses, 1 to advocacy, and 2 to the understanding of a case from tribunal's perspective. And if you're looking at the first group, the first 6 criteria, which are the first 6 points you see on the figure, you'll see that systematically, to the extent people had a preference, it was less good rather than better. The exception is when it comes to putting questions to witnesses and experts by the tribunal. Putting questions in general, that's where things were slightly more even. And then you shift a bit further down to the tribunal's understanding, and there you see that from the tribunal's perspective, actually fully remote hearings are a lot better in terms of putting questions. But then the other part of a tribunal's understanding is, at the end of the case, do they feel that they've understood the case the same or better than they would have in a physical hearing? And while a lot of people said it's the same, you had a significant minority, we're talking about over 20%, saying their understanding was less good, whereas none of them said it was better. And that is an area of caution. Some arbitrators may be comfortable, or many arbitrators may be comfortable with fully remote hearings, not all of them. And if the point of a hearing is to help the tribunal understand your case and assess the evidence, then that's something you need to bear in mind. I'll pause briefly on the advocacy point. You can see there that there were mixed views. Overall, if you weight it, people tended to see fully remote hearings as less conducive to effective advocacy than a physical hearing. A couple of additional points just to put this data in context. Amongst the questions we asked our participants in the survey was, had you had prior experience of fully remote hearings? In other words, when you're giving us these answers, are these what you imagine they will be, or is this based on actual experience? And what we found was that 64%, in other words, some 130 participants in the survey already had experience of fully remote hearings. And of these, 78% their experience was within a week. In fact, about half of the people who'd had less than a week experience reported having had only 1 or 2 days experience. So the collective experience of fully remote hearings at the time of filling out the survey was reasonably limited. And to go back to some of the other things that have been said in this discussion today is, there's been more experience since. It will be interesting to see how the collective experience has evolved. But at least based on the experience people already had, this is the views they conveyed.
Fez, I do think one important point to keep in mind as we look at this data is that the experience of participants with in-person hearings as opposed to remote hearings is obviously dramatically tilted towards the former. People have a lot more experience, even if they've done some remote hearings with in-person hearings. And as a consequence, it's not all that surprising that participants feel that they can do things better in an in-person context as compared to a remote context. They've had a lot more experience, a lot more practice, so to speak, with in-person hearings. I wonder what this graph will look like in 12 months or 18 months time when the level of experience doesn't necessarily even out or level out, but at least isn't so dramatically different.
Sure.
If I may just jump in here and add something very briefly, I totally agree with what Gary has just said. I mean, we all have different takeaways from the data, and this is why it is such a rich, field for everyone to look at the data. But one of my takeaways from this particular chart is I was really surprised to see how many people actually thought that fully remote hearings were better than in-person hearings. I would not have expected that answer to be as strong. And if you add up the numbers of same or better, you often get beyond the less good answer. And I'm sure maybe there are some other charts that people will look at, but it's definitely something that I found striking when I saw the results.
I thought the same was true with respect to the tribunal's understanding of the case. At the end of the day, it's the tribunal that you want to persuade, and their views are pretty important on that.
Indeed, very telling. And if we now scroll down, Hafez, then maybe we get to the spider charts, which are also very interesting in terms of satisfaction. And here we have, Gary, a question to you. We have several spider charts. The one that I find in particular interesting is exactly this figure 7.9, counsel and tribunals' experience of fully remote hearings. Can you explain these spider charts, which are a bit different than the charts that we saw before, but probably will come to the same analysis?
I understand the spider charts, and Hafez, I think, is the true master of these. The more area that is taken up by the diagram, the solid colored figure in the middle, the more positive the experience.
Sorry, Gary, your audio.
Sorry.
Yeah.
I was saying, and that Hafez is the true master of these spider charts, but they're another way of portraying the data that we've seen in the bar graphs. The more space that's taken up by the solid colored figure in the center, the more positive participants' views are of a particular aspect of the proceedings.
Hafez, would you like to add something to that?
Sure. So just maybe to help our viewers understand these charts, the ring that's marked as 2 is, as it were, the average. So if you had a figure that drew the line at 2 perfectly, that would tell you that the aggregated view for, in comparing fully remote hearings with in-person hearings, is that they're the same. And so the comparison with that 2 line tells you where people situate. One figure which Gary may wish to comment on, which was very different from all the others, was the one that, based on the experts' responses to the survey, because its shape is like none of the others, where the results are reasonably evenly distributed.
Well, that's I think it's a good segue to a question that I have for Anneliese, which is, I find all this a little bit sort of paradoxical. All this data, which is very useful, by the way, does indeed point to some sort of preference for physical hearings. But we saw earlier that the community was very positive about fully remote hearings. What do you think, Anneliese, on this?
I mean, I think, as Maxi said, we need to be cautious about this data at the minute, because sure, there is a preference for in-person. And as Gary has said, that may also come from experience. So if you think about the experienced advocate suddenly having to do remote advocacy, it's not surprising that they think it's better to do it the way they've always done it. By contrast, certainly I've trained some young lawyers that their remote advocacy is amazing, often better than experienced advocates. So I think we'll see, because I think some of it is a familiarity thing. I think the other thing that we really want to try and do when we get data again is try and get as much client feedback as possible. Hafez, I don't know if you've got the charts. The answers can be very different depending on who you are. So question 42, Hafez, if you could get that up. That basically showed that in-house counsel and the counsel team are now as likely to propose fully remote hearings as they would in-person hearings. And then for tribunal secretaries, that was a very definite preference. So I think that's quite interesting, depending on who you are, where the answers come out. Again, whilst I'm just waiting for Hafez to get that up, question 45, which was one of our questions, again, you saw that, for example, third-party funders loved remote hearings. Now, why do we think that is? Because they may be dealt with more quickly and more cost effectively. I think it would be very interesting to get as much client feedback as we can. My own personal experience of feedback from clients is, for example, remote mediations. Clients love them, and I'm not sure actually mediations will be going back to being in person, because they see it as a much more efficient way, particularly in commercial arbitration, of seeing if they can reach a deal, and they don't see the need to travel and sit in a room with lawyers, much as they like us, for a day, or, you know, so it's very interesting. And I think that we may be surprised by what clients think. So yeah, I think those who are most conservative are counsel, lead counsel, more positive, more willing, in-house counsel, third-party funders, as I say, and hearing centres. But hearing centres have obviously always been reasonably in favour. And again, it will be interesting to see how the technology evolves. I think the other thing that we haven't really talked about was the overwhelming numbers in favour of case management remotely. So across practitioners, the average likelihood was 72%, the median was 80%. So meaning that 80% of people would now, and then arbitral institutions, it was 90%. I think that is a change that is here to stay. And the other comment that was interesting is that people feel cases are being better managed by tribunals. Certainly my own experience is tribunals have been very creative about jumping on a Zoom call and telling the experts they need to turn up and questioning the experts at a much earlier stage, that actually then has huge benefits for the final hearing. And, you know, it's amazing, you can send 1 million emails, but if you actually get people face to face, even on a screen, you can resolve something often very effectively. So I do think it's dangerous to talk in headline. I actually think there's a lot of positivity behind it. And I think the point is that in the longer term, it's not here to replace anything necessarily. It's just an additional tool in the international arbitration toolbox, which ultimately is about resolving the client's disputes for them. So I think, yeah, I think that's my answer to your question. I don't think there is a paradox. Yeah.
No, I fully agree, Anneliese, and I like the idea of a tool, which is definitely sort of resonates with my own perception, is that it's going to be an option, not necessarily substitutive. But I just wonder, for the future reference and the survey, and that's, I think, a comment for the panel at large and perhaps the participants, whether the results would be different if we took into consideration age or generational responses. If we have generation Y, Z, or the alpha generation responding to these questions, more familiarity with IT and the use of, you know, technology, and many of them, actually, the very young ones are living their lives online. Would we have a difference? I'm very mindful of the fact that the responses come from the existing leading generations, being the baby boomers or Generation X so far, which we are more familiar with the physical face-to-face type of things. But, you know, maybe age or generation would have its impact on this.
Maybe. I think the only word of caution is that those people also need to train. I have heard a lot of feedback that they're missing having hearings, you know, where you walk to the hearing together, you chat, I think for their training, there is going to be something missing. And sure, you can train online to a degree, but I think, you know, there is no substitute sometimes for in-person contact, particularly when someone's learning a profession.
Absolutely. Hafiz, I think we're back to you. We have, I think, generated a lot of interest, and we have many questions in the Q&A. So over to you. Thank you very much.
And that's all. Thank you. And you're right. There are a lot of questions in the Q&A. Maybe we can start with this one coming from Moscow, which I will address to Maxi or Niuscha. You can see who's answering it. And the question is this: do you think that remote hearings can badly affect due process or violate parties' rights, for example, to be heard? And there's a related question, which you may want to address with it, which is, do you think fully remote hearings can be the subject of due diligence, due process paranoia in the future?
Maxi, why don't you take the first part of the question? I take the paranoia one.
Sounds good to me. So I think it's a very good question, and I think one that it cannot be answered by a straight yes or no. I think there is, as always, an important balance to be made. Of course, an arbitral tribunal, from an arbitral tribunal's perspective, imposing a remote hearing on the parties, because if both parties agree, we don't have any issue with any of the due process concerns that you raised, but imposing it on a party who disagrees to have a remote hearing is a difficult task for an arbitral tribunal, and one that requires a significant balance exercise. The tribunal, however, within its broad discretion, procedural discretion, may decide, even against the will of a party, that it is more important to proceed with the case, even in a remote fashion, than not having a hearing at all, and therefore delaying the outcome of the proceedings quite significantly, given the length of this pandemic. So the mere fact in and of itself of a remote hearing does not seem to be a violation of due process. I've looked at decisions around the world in various jurisdictions, and I have not found one that the mere fact of having a remote hearing it could be a violation of due process. Niuscha mentioned the recent decision of the Austrian Supreme Court, which was a challenge to the entire arbitral tribunal for precisely having conducted a remote hearing against the will of one party. And it very, very clearly came out to say it is not in and of itself a violation of due process, looking at the specific provisions of the Austrian Civil Procedure Code, but also the European Convention on Human Rights, Article 6, the right to a fair trial. But the same, as I said, is also in other jurisdictions. Now, of course, there might be situations, if there is a technical issue or if there are other specific circumstances where it is better for the arbitral tribunal to postpone the hearing and have a later date for the hearing set, hoping that this might be in person, or at least giving the parties additional time to prepare for a remote hearing. But this is taking into account the specific circumstances of the case, and it's not a principled decision against remote hearings.
It will come as no surprise that I fully agree with Maxi, and that also answers actually the second part of the question that was put about the due process paranoia. Now, we have heard before the remote hearings came into life, as we see it in this year, we have heard so much about this due process paranoia and how and whether the tribunals should give in at objections of the parties, or one of the parties. And so I think this was a test run precisely for putting maybe an end to this whole subject matter of due process paranoia, because there has been very solid decision-making and discretionary decision-making on the part of the arbitral tribunal with regard to actually deciding against the will of a party to have a remote hearing. And I have to say, I myself am pleased about that, to see this, that the tribunals did not shy away, that they did decide in favor of remote hearings, of course, taking a very balanced view. And that's where it comes down to, that you have to take this balanced view, as Maxi set out, the considerations that you have to take, be it procedural. Mostly nowadays, it's actually more practical consideration that have turned into due process procedural considerations as well, such as time differences and how to deal with that, and equal treatment. So as I said, I hope that this topic of due process paranoia has now been fully tested, and we can leave it behind us, and we can now maybe come out of this as a even more enforced, more strengthened decision-making entity, if you want to call it, as for tribunals actually to take these decisions in a balanced way, of course.
Actually, maybe one thing we can do is, after the event, we'll be sending, sorry, forgive me, we'll be sending around a link to the recording of this event, and maybe what we can do is include a reference to the Austrian Supreme Court decision, as well as Maxi's note on it. Amongst the other questions in the Q&A that have been sent to us, one has been specifically addressed to Gary and Mohamed. And the question is this: do you think the quality of awards is likely to suffer as a result of remote hearings? And this particular participant is based in India.
I'm at your disposal. If you want me to go first, and Gary can definitely comment and share his thoughts. I took particular note with the reference to the word suffer. It implies a sort of a negative impact. And my view is, an immediate answer is, I don't think the quality of awards would suffer from remote hearings at all. In fact, you may have arbitrations with no hearings, documents only. What I think is going to happen is that possibly efficiency in rendering awards with lockdowns, restrictions, and remote hearings may be positively influenced, as we've seen from some statistics and institutions, faster rendering of awards. So in a nutshell, I don't think it's going to suffer in terms of quality. I think the quality is a function of whether the tribunal has all what it needs to render the award and has put in the expected effort to render a proper award. And being remote or non-remote does not really impact the quality per se. One final thing I feel tempted to add on the paranoia aspect is that I would caution against putting this behind our backs, because the Austrian Supreme Court decision is, yes, a very useful development, but there are many other parts of the world and many other courts that we are going to wait to see what they have to say. And parties with the increase in remote hearings will have very innovative and complex arguments about this. So we've got to wait and see. It's going to evolve with time. So anyway, thank you.
Just very briefly, Hafez, I think we all like generalizations, and the answer, in a sense, wanted one. I think we need always to remember that arbitrations are like snowflakes. There's no average or standard or normal arbitration. In some cases, an arbitration hearing may be better remotely. In some cases, for example, because of time zones or difficulties in access, it may be a lot worse. The same thing, of course, goes for awards. I think it was striking, as Maxi pointed out, that a very, very significant majority of tribunals felt that they were better prepared as a consequence of remote hearings than in-person hearings. And I think that's perhaps not an answer, but a reasonable indicator, a good data point in terms of the quality of awards. But if you're in a circumstance, and this may explain the negative views of some respondents, if you're in a case that's that's large, sprawling. You have issues of time zones. You have issues of being able to meet with some witnesses. Then both the quality of the hearing and therefore ultimately the award may suffer. I think, though, trying to give a generalization, I would agree with Mohamed and draw also on the data that we received from a very large number of participants. In general, the quality of hearings and hence of awards seems not to have suffered. Some people, in fact, think that it has improved. I'll be interested again, though, to see what the world looks like a year from now when we have a lot more experience, perhaps negative, but perhaps also positive.
May I ask still one question to Hafez and Gary and also Anneliese? And this is on the point about the results of the answers from the tribunal secretaries. I think Anneliese mentioned that they have been they considered that it will be more likely that in the future there would be fully remote hearings as well. Now, and this is an encouragement for all three of you, since Gary said this is work in process and it's actually also dynamic still, that whether it would be actually also worthwhile to look at now in retrospect at the answers that were given during the time of June, July in the survey. So to maybe also to the same players. And I say that, and I picked on the tribunal secretaries because while I know for a fact from associates in our firm who act as tribunal secretaries that they were thrilled that the remote hearings were taking place, when they took place, they actually realized that they are blanked out on these Zoom hearings or WebEx hearings or whatever video conference hearings. So their exposure, while the name was there, but in terms of like visual exposure was diminished precisely because we have now moved to digital remote virtual hearings. And I find it actually a quite interesting phenomenon, while at the same time it's exactly the generation that embraces the technology. It might be also the same generation that is maybe cutting itself out through that development. And so is this something, Anneliese, you want to discuss or you want to mention it? And also for Gary and Hafez in particular to look at further?
Yeah, I mean, Hafez and I were having a discussion the other day about, I don't think we should assume the technology will remain as it is. I mean, Zoom obviously has been hugely used and is effective to a degree. I understand that in China now they're developing kind of virtual hearing rooms where you would be able to see everybody. So the notion that only a limited number of people appear on the screen may not endure. And I think if, that would be a massive move forward if you could virtually recreate the hearing room on the screen. And I've also talked to some arbitrators who are concerned that they can't see what's going on in the room, because you can tell a lot sometimes by looking at what the opposite party are doing when someone's being cross-examined, or little things that happen. And I think that is important, and seeing people. So I think it depends. Certainly LONDAP is looking at that kind of technology, as well as changing the way in which, what type of hearings may still be in person, maybe changing, so smaller hearings, not so much, etc. But I think if that technology could get off the ground, it would be a game changer. Until then, it's sort of up to the tribunal as to who they have on the screen. I hope most tribunals, though, would still introduce the tribunal secretaries at some point, and their work would be seen. So I don't think they're invisible, but I don't know what Hafez and Gary think.
I think it's hard to tell how slight differences in technology as we perceive it compared to in-person formats affect us one way or the other. That's one of the reasons we did the empirical study. Maybe tribunal secretaries get more, if I can put it this way, name recognition by having their name on the screen as opposed to their face or being present in the hearing room. I don't know the answer to that myself. I do think as we get more experience with different aspects of the technology, we'll figure out how to address those kinds of concerns. How do you make sure that the tribunal secretary fully participates? But other concerns, how do you, as counsel, read the tribunal? How do you see how the tribunal is reacting to a line of questioning or something else? I've certainly heard it said that you can read the tribunal less well in a remote context. I've been in hearings though where I feel as if I'm seeing the tribunal better, not worse. So I think a lot depends on the circumstances of the case and how one uses the technology.
Can I add something interesting to hear about the views of others on that I faced in a remote hearing recently? One counsel, not the lead one, but one counsel who was cross-examining a witness, a female, did not prefer to turn on her video. It was time zone difference. And she said, you know, I'm not going to turn on the video. So how should the tribunal deal with that? I mean, it was an interesting thing. The tribunal wants to see the person, the cross-examined witness, you know, also expected. And the view was, well, we can be doing this audio. Why do I have to turn on the camera if I don't feel like doing it? At least, you know, maybe for whatever reason. And likely so. And that was a moment, a bit of an interesting moment, I have to say, for the tribunal, because the tribunal felt, again, because of the gender, because of many things, they felt, okay, so we will proceed with the audio. And the opposing counsel was not very content about that. But so be it. I mean, that was an interesting development. The other thing is that I see with the younger generation, and if there are parties subject to budgetary constraints with remote hearings, many more members of your team can be silent participants and can join the hearing and benefit from that, compared to the few people that you can travel with because of budget and stuff. So I think this offers also more opportunity to the younger members of certain teams, even if they are silent participants. But these are just two, you know, 2 cents worth developments that I thought, you know, maybe it's worth reflecting on.
If I may contribute, and it depends. Comment, just to follow on from both what you and Gary were saying in terms of the technology. One thing you can set up on Zoom is to hide participants who don't display their video. At which point, yes, you can have more people in the room. But to go back to the question, does that actually help in recognition? And there may be a broader segue here to diversity, which is, if you're only seeing some of the people in the room, what does that tell you about the shape of the community and what it looks like? But it's just adding further food for thought. And I think there are more questions in the chat, so we can continue with those. Unless someone wants to take it, I'm happy to put it. This one is from Catherine Paisley, and she asks, does the book address potential constraints on the process and the resulting risks, and how can these be addressed?
I'm happy to take a step. Catherine has always very good questions and difficult ones. So yes, the book addresses very practically how arbitral process might have constraints, as you put it, from remote hearings. I suppose you're thinking here the very practical issues of time zones issues, how to make sure that a witness that is giving evidence remotely is not unduly influenced by the outside influence. Niuscha's chapter in particular, who has the sample order on remote hearings, not only addresses or deals with these issues, but also gives you a solution how you can include provisions in your sample order so that these problems can, to the extent they can be dealt with, be dealt with. The only other thing I would say, and sort of going back to my initial remarks at the beginning of this seminar, I think it's not only a matter of issues with the arbitral process that we should address because they're done remotely using modern technology, but it also gives us the opportunity to think about the process as a whole. Because physical hearings are in one room, in one place, they're usually conducted in 1 week while everyone is together. Remote hearings has allowed a lot of people to think, aren't there better ways of dealing with this? I had certainly one, for instance, where we didn't have the closing submissions straight after the last day of evidence, but there was a pause of 1 day between the last evidence hearing day and the closing submission, which allowed counsel not to have a sleepless night, but rather to digest the evidence that has been heard during the hearing and address them in closing. And similarly for the arbitral tribunal, to digest the evidence that has been heard, maybe even confer on some of the questions that members of the tribunal had before putting them to the parties in closing. So this is just one example how remote hearings give us more freedom to maybe shape the process as a whole to make it more efficient and, as I said, tailor it better to the specific needs of a particular case.
Thank you, Maxi. I think we've covered the questions in the Q&A. Unless any of you wanted to add anything, it probably falls to me then to thank you all for your time, for your valuable insights. As Anneliese mentioned, we're looking at how to reflect these learnings on the technology and the design of LONDAP. And for that, we're privileged to have both Gary's and Anneliese's insights. And we're very glad to be able to do this joint event and put forward this valuable book. There's a lot of learning in it, as you hopefully gathered from this event. It's touched upon a lot of areas of practice. And so we thank you.
Thank you, Hafez, for putting it together, and thanks to Gary and Anneliese for presenting and you presenting your chapter.
Yeah, and thanks
Thanks
to
so
everyone
much.
who's joined us. Yeah, thank you.
Thank you very much for the questions.